Recorded.
Good afternoon, everyone, and welcome back to this episode of Digital Law News. I think this is now episode 19 of our series. So I'm joined today by my colleague, Peter Wright of Digital Law. So this is a podcast brought to you by Digital Law and co-produced by Anson Evaluate. So we just have a little chat about some of the news stories that were in the news this week and last week. That relate to the work we do at Digital Law, which is anything to do with technology, social media, data protection, and therefore. So I'll just pass over to Peter to just introduce himself.
Thank you, Laura. So my name is Peter. I'm the Solicitor and Managing Director at Digital Law, and indeed these weekly discussions are to give you a flavour of the issues we're looking at in digital law each week when we're looking at the developments with regards to what's happening in the world of technology, digital technology and the law. So these are the things that we're staying on top of each week and we're sharing it with you. So over to you, Laura.
Great. So the first one we're going to be speaking about today is the fine by the ICO on Marriott hotels. So this has been a long coming fine, just like the one for BA was that we spoke about a couple of weeks ago now. So the ICO have issued a fine of £18.4 million for the major data protection breach that affected up to 339 million guests of Marriott. So this was a breach that actually took place between the years of 2014 and 2018. Not just on Marriott, but also the company that was is now owned by Marriott, but was a separate company beforehand, and then Marriott bought them out. So this also included 7 million guest records for those in the UK, and the company actually failed to put in place appropriate safeguards to protect the personal data. However, the ICO have now acknowledged that this has improved. So it must be noted that the fine is nothing like the £99 million fine that the ICO had thought that they were going to impose on them. But it must also be mentioned that this is a massive deterrent for future companies as well, just like the one that was imposed on BA a couple of weeks ago.
Indeed, Laura, that's absolutely right. I mean, we're talking about massive fines, given that the most that you used to be able to fine under the old Data Protection Act 98 was £500,000. So to say that 18.4 million isn't as much as was threatened, well, no, it isn't, but it's still many times over, far bigger than a company would have expected to be fined for an egregious breach of data protection law under the old regime. And indeed, this fine and the BA fine, I think, bear comparison with other examples of enforcement across Europe, where regulators are fining different corporations for breaches of GDPR, and this and the BA fine bear up, right up there with the very biggest fines that other regulators have handed out. For example, the 50 million that Google chose to fine CNIL for breaches of GDPR as well. The other interesting thing is the issue of liability. I think you're quite right to sort of flag up the fact that, look, a lot of this comes down to Marriott having purchased another hotel group, and it was problems within the system within that hotel group that have led to this massive fine. So we're used to, when it comes to the world of mergers and acquisitions, that huge amounts of due diligence have to be done, where you end up reviewing everything about the organisation that you are purchasing. And one of the things you should be checking as part of that due diligence is the IT and the integrity of their systems. As it is, the problem here was only identified when they actually started doing some work around the system and found that it had been heavily compromised. Ideally, when it comes to, therefore, to these sorts of takeovers, part of the exercise should be to, for example, have a pen test undertaken against the system. Actually I would, before I was undertaking a purchase like this, I'd want to get a report telling me what are the systems like, let's actually try and breach them. Let's see what happens. Do we find that there's already someone present in there? Do we find that there's evidence of other people having undertaken attacks before? These are the sorts of things that you're going to want to know before you then go through with the takeover. And if that had been done, then they would have saved themselves this £18.4 million fine. But if anything, for Marriott, it's almost the reputation with this as well. You know, a lot of the world's biggest hotel groups store huge amounts of personal data, and now people are going to associate Marriott with this fine and their perceived double standards, when actually it wasn't the core of Marriott organisation. It was actually the organisation they were taking over, Starwood. But they are now where they are. At least the fine is down from £99 million, which is what they're originally indicating. You know, let's face it, 2020, the leisure sector is doing pretty badly, so they'll have made representations to the effect that, you know, 99 million might wipe us out. At least at 18.4 million, they might have a chance of being able to continue in some way, shape or form afterwards.
Yeah, definitely. And I think you're right in mentioning that. Obviously, this year has had an impact on both the BA fine, British Airways, and the Marriott fine as well. And without this year, we probably would have seen the bigger fines as well being actually enforced. But yeah, I think it's rightly so that they have been reduced, just to give them a fighting chance of actually surviving through this.
Exactly. They have to take account of the fact that, you know, these corporations are big employers at the moment. Yeah. The biggest you know, concern for governments when they're carrying out regulation like this is making sure, albeit that the fines serve as a deterrent, but also to make sure that hopefully the organisation being fined is still there to employ thousands of people afterwards as well, if it's all possible.
Yeah. So moving on to our next one. So this is one that we actually spoke about a couple of weeks ago now, I think. It might have actually been just last week, but this is regarding Experian's GDPR violation and how it is leaving companies to scramble to understand legitimate business interest. So the enforcement notice that the ICO have put against Experian could actually see the giant actually on the hook of a fine of around $24 million. So this is an investigation that was carried out by the ICO and was carried out on 3 of the largest credit reporting agencies. However, unlike the other 2 agencies, Experian actually failed to meet the requirements of the regulator and actually cooperate and meet the regulator's requests. So this is why the enforcement notice has been put on Experian rather than all 3 of those who actually violated the GDPR. So a key issue was raised in this notice and the investigation, and this is regarding the legitimate interest. And I think here it is all about whether businesses who then buy personal data off other companies can then rely on business legitimate interest when the other company who bought that, who was selling that data, they relied on it. So it's whether that reliance on that basis actually transfers to the other company, or they have to kind of come up with this new legal basis.
Thanks, Laura. Yes, it's this is a fascinating one on 2 counts. First of all, credit reference agencies. When I was conducting conference calls with organisations 2 years ago on the run-up to the introduction of GDPR, one of the questions was, well, you know, all these new laws are being introduced. How will that affect credit reference agencies like Experian, given the fact that they hoover up vast quantities of personal data about individuals from all corners of the internet? They hoover up records from banks, details of what you purchase, what you buy online, what your habits are. All these sorts of things are hoovered up by credit reference agencies so that they can then come up with their individual scores. It's not just, oh, you've taken out a credit card of someone, oh, you've been paying back a loan. So they take a lot of other things into account when they're deciding that what your score should be and can you then borrow. And when you're then saying, well, every single item that you process should be under Article 6 pursuant to consent or a contract or legitimate interest, you then got to account on each of those bases. You know, this data that's being processed here, what's your basis for doing that? And legitimate interest, I think, has become a bit of a catch-all. This is the second point, is that it's used by a lot of organisations like a catch-all. Oh God, consent's difficult. We've not really got a contract that we can do this under. It's certainly not, you know, an essential basis that we're doing this. It's not pursuant to a public task. Oh, don't worry, we'll use legitimate interest. Just throw it all in there, and we'll say that's the basis that we're doing it. And regrettably, you can get away with that, but probably, you know, 90% of the operations of how a corporation handles its data, you might even have a shot at saying it's legitimate interest because it's legitimate, pertains to how we're running the company. But it's the fact here that they were using this information for marketing purposes, where they purchased the data off another company. So in this scenario, people receive the direct marketing emails and they say, I never gave any data to Experian. I never gave them permission to do this. So then the ICO gets in touch and says, you've got this data, you're contacting these people. Where did you get it from? Experian goes, don't worry, we purchased the data. Right, okay. What's the basis upon which you're processing the data? Oh, legitimate interest. Well, how can it work like that? This is where it comes into a problem, because I bet the corporation they've purchased it from, they can find something realistic under Article 6, be it legitimate interest or consent. They'll have that. They've got the records, they've got the evidence. They can say, this is the basis that we're using. All Experian's got is the contract it's got with whoever it was they purchased the data off. Or if they're lucky, a legitimate interest template, something like that. But when the regulator's knocking on the door saying, the basis for contacting all these millions of people, potentially, I mean, 24 million people, it must be a large volume of information we're talking about here. And they've been left a bit like the emperor with no clothes, going, oh, it's legitimate interest. So you've got no records under consent, you've got no other basis that you can adequately point to say this is the basis we're processing the data, and you're left with nothing. And this is the problem that Experian now has, and this is actually a problem that I think a lot of corporations are going to currently be running across, because there are a lot of people out there still selling this data to the unsuspecting, and the people that are buying it are thinking, well, we can use this for marketing, we can carry on, this is what we did before, we need this to grow our business, we need to buy this data. And then all it takes is for some of the people receiving your marketing communications to report that to the ICO, and this is where you find yourself. And this is going to set Experian back now. Will it lead to changes within the credit industry in terms of how and where they get their data from? I wonder. But I can certainly imagine Experian won't want to be bitten by this again, and will be thinking quite carefully about where they're buying their data from as a result.
Yeah, definitely. I think your last point there about data subjects, it only takes a couple of them to complain. I think that is really important, because since GDPR has come in and over the last couple of years when it's been enforced, a lot of data subjects now are becoming more aware of the rights, and companies are informing them of the rights. So when they're just exercising this, it is a big problem now, because whereas before GDPR came in, although some of the rights were already in place, now people are more aware of it, and they are actually exercising the rights rather than just ignoring an email. They're actually then reporting it to the ICO or reporting it to the company, and then it's been made aware. Yeah, exactly.
And I think it's a real. This is something that I think a lot of business owners and managers haven't yet twigged. In that I think they sometimes think, oh, well, we can carry on. No one will pick up on this. Like, for example, have you really got a basis to process this data for marketing purposes? Then people tend to think, well, no one's going to report it to the ICO, or if they do, the ICO won't pick it up. They've got bigger fish to fry. Clearly not. And Laura, you and I are on this update looking at what the ICO is doing every week. They are still carrying on enforcement every week, regardless of the pandemic. They've got a big team of people, very busy in their office in Wilmslow, all working from home, and they are still looking at cases and have been rolling out enforcement for months now. So don't think that just because it's 2020 and the pandemic, or don't think that the ICO isn't out there looking at this sort of stuff. And I think we're going to keep on getting enforcement like this until businesses get the message.
Yeah, absolutely. So just moving on to the next one. So this is the GDPR lawsuit against Oracle and the Salesforce, which is then moving forward. So this is a mass lawsuit against those two companies. And the person who's bringing this is called Rebecca Rumble, and she is a privacy campaigner and a data protection specialist. So she is filing this report as the data processing policies and practices of the two companies basically isn't good enough. And that she is bringing this to the High Court, and they are going to be scrutinising their practices. So the damages that she will be seeking is up to and in excess of £10 billion, which could conceivably lead to awards of £500 for every internet user in the UK. So Rebecca, who is the person who filed this, has said, "Enough is enough. I am tired of the tech giants behaving as if they are above the law. The data these companies are compiling on ordinary citizens is terrifying. With their tracking technologies in use across the most popular websites, it is hard to escape from their data collection."
Indeed, I find this lawsuit absolutely fascinating, and there's an awful lot of ifs and buts that have to happen in order for them to be able to succeed in the damages they're quoting there, 10 billion. And I think every user in the UK shouldn't be relying on that £500 arriving anytime soon. But the basis for the claim ties into, I think, a lot of the popular feeling out there at the moment about how large corporations are potentially undertaking their operations, collecting huge amounts of data, monetizing that data. And in this instance, it's looking at these two massive software corporations and how the systems that they have designed are potentially accessing such large amounts of data online without people's permission. I think in the past, one key thing here actually, Laura, is, as you just said on the last answer, in the past, I think people weren't necessarily aware of or bothered about it, whereas I think within the last couple of years, people have realised, actually, yeah, this is all my data that's being used. And the fact this then goes into the pockets of Google and Facebook and Amazon potentially, and Apple and Microsoft with their practices means that people are increasingly aware of that and increasingly a bit cheesed off at the idea of their personal data being used without their permission for other people to unjustly enrich themselves. So now that's kind of the popular feeling. To then put that together into a lawsuit and say, I'm going to chase after these corporations for such large amounts is brave. Let's see how it goes. It could be that we'll be sat here in a year or two's time saying, wow, that's a landmark judgment, and it's great that they've now enshrined and found these practices of a fault. Or it could be that in a year or two we're turning around and saying, this shows that you can't rush off to court with every single issue that you might want to litigate, because a big thing like this, big corporation, a big suit against two big corporations, what if you lose? Then you've got the loser pays in terms of costs. So you might find that you're then paying your own costs, which are going to run into hundreds of thousands of pounds, and also you'll be paying the costs of Oracle and Salesforce, and those costs would be significant. I would hope that Rebecca and the Privacy Campaign organisation that she's involved with, I would hope that they've got really good insurance in place, so that if this should fail, the insurers will pick up the tab. I would expect and hope that is the basis upon which they're operating, but let's see how this case rolls out. I think is going to be the what we have to think for now.
Yeah, definitely. And I think this really nicely ties into our next story as well, which is about the DCP, so the Irish Data Protection Commissioner, and the fact that they're having to pick up the legal bill of the EU-US data transfer case. So this is kind of what's happened to them. They've gone in thinking they're going to win this case and put all their money into it, and now they're having to kind of foot the bill on that. So, and just to tell you a little bit about this story, so the Irish High Court have put an order on the Irish Data Protection Commissioner to cover the costs of Mr. Schrem's legal team in relation to the EU-US data transfers that came before the Court of Justice of the European Union. So just to give you a little background about how long this lasted for. So the case ran for over 5 years. It was heard before 3 Irish courts before then moving on to the EU level at the Court of Justice of the European Union. There was up to 25 solicitors and barristers at the High Court hearing alone in Ireland. There was more than 45,000 pages of documents submitted by Facebook and more than 6 weeks of hearings. And Facebook took every option to expand and delay this procedure, so that's probably why it progressed for so long. We all know that Mr. Schrem's actually succeeded against Data Protection Commissioner and Facebook earlier this year, and now he's entitled to at least his legal costs from the plaintiff, which is DCP, of course, DPC, sorry, and under the loser pays principle. So yeah, that just highlights the risk of doing such a large case like this. Not kind of the same case, but a case where it could go wrong, and then you could be footing the big bill that comes along with it.
Indeed. So I can, with the last one, I hope that they're insured. Because the thing is, with litigation like this, the figures that you're looking at mushroom into huge amounts of money very, very quickly. I mean, 25 solicitors and barristers. Now, I remember at one time instructing a QC on a case who was going to come up for a conference in the north of England. So they'd read through some papers, they jumped on a train, 2 hours. They were then in the conference for a few hours. They then stayed in a hotel. Following morning, jumped on the train back down to London. And then the bill came through. I don't think we got much change out of £20,000. And you think, that's a good day's work. And the particular QC there is now someone who appeared on a lot of television for various hearings that he's been involved in that have ended up being televised, cross-examining politicians, business leaders, etc. So you're talking about someone at the top end, but the principle, particularly here where we're looking at very fine principles of data protection law being argued in front of the Court of Justice of the EU, the people here involved are specialists. They will have been very expensive, and we are talking about 5 years worth of their time. And they've not been engaged on this issue alone, but when you're thinking of potentially tens of thousands of pounds a day, you can quickly see where that bill could become rather significant. That figure of 45,000 pages of documents is a big figure. It's not the biggest, but it's a large one. And of course, 45,000 pages will have had to be looked at. So those solicitors will have been engaged in reviewing documents, deciding what's going to be disclosed and what isn't. So 45,000 might have been submitted by Facebook, but I bet that they reviewed tens of thousands of pages to whittle it down to 45,000, which is what the court agreed could then go into the bundle and used as evidence. So when you've got such massive amounts of work being undertaken, you can imagine that the bill that Facebook lawyers submitted immense. I mean, on its own, you can imagine that bill will probably dwarf the annual budget of the Irish Data Protection Commissioner. So yeah, I really hope that they had some good insurance in place and that they weren't just relying on the advice from their own lawyers, which always said, don't worry about this, you'll win. Which actually, given the previous outcome of the Schrems 1 decision, you'd have been quite foolhardy if you believed that you knew exactly where this case was going to go. Indeed, on the back of Schrems 1, I always felt, when they said, oh, there's going to be after the EU Privacy Shield was set up, the US Privacy Shield, and after it was clear that Max Schrems was going back to court again, there was only ever one way that case was going to go. And while clearly a lot of time has been spent trying to prop up the defence in this instance, it was only delaying the inevitable. So therefore, they've now got a huge amount to pay, and like I say, I hope that they're insured well, and I also hope they can afford to pay next year's premium, which you can imagine, like all insurance, goes through the roof. You know, the minute that you make a claim, the premiums will automatically go up massively. But I'm sure, Laura, as a young driver, you're familiar with insurance enough in that way. But you know what? Insurance goes up in the same way, whether it's your car, whether it's indemnity insurance, or whether it's insurance like that for these sorts of cost issues.
Yeah, absolutely. Like you said, it's one thing having insurance now. They're gonna probably be able to cover this through the insurance, but they might not be able to afford their insurance next year.
Indeed, particularly given that everyone's premium seems to be going up, because guess what? Businesses are having to claim at the moment because of the exceptional circumstances. So it's not a market you want to then be going out and having to get a new policy in order to pay even greater premiums to renew. But that's another story.
Absolutely. So moving on to our next one. So this is regarding the NCSC and a report they've recently put out. So this is about the highlights from the last 12 months at the NCSC. So this was covered in I think it was like a 190-page report. But also they have a short, I think it's about a 5-minute video on their website if you just follow the link on the page. And it basically is the CEO, Lindy Cameron, who actually just gives a brief overview of some of the things that the NCSC has achieved this year and have done. So just to take you through a few things, so just the ones that are listed on the screen. So they have taken down 167,000 phishing scams, removed 113,000 fake online shops, and have blocked 22,000 malicious sites. They have worked with more than 140 countries to protect things against the cybersecurity threats. They have helped those individuals and businesses when working from home, such as publishing guidance on how to work securely. They have launched a suspicious email reporting service, which has had 2 million emails reported. They have launched a new scenario for their Exercise in a Box, which is specifically targeted at businesses whose employees are having to work from home. They responded to 723 of the UK's most serious cyber incidents, which have been more increasingly ransomware attacks. They've helped the NHS with cyber defence and have secured vaccine research organisations. They have defended the UK democracy by helping MPs being able to vote online securely, and by helping the Register to Vote website when the election last year was occurring, and making sure that the site didn't go down when a lot of people were registering to vote. And they are also now encouraging girls to think about a career in cybersecurity, because clearly they're seeing a lack of feminine figures in that type of work as well.
Thank you for that, Laura. Just while you're reading that, I've more and more thought that this is what we need today. This is a piece of good news, this review. It's the first day of the UK's second national lockdown. I hope fervently there won't be a third. But in the backdrop of a very difficult year for everyone, for the whole world, Britain is showing here with the National Cybersecurity Centre what can be done to create a safer, better environment online in which to do business. And that's what its purpose was when it was first set up in 2015. You know, this is the idea of taking the government's sort of the military intelligence GCHQ work, where a huge amount is done in terms of cyber, defending the country from cyber threats, to then open that up with the public-facing National Cybersecurity Centre, to share information with the public and private sector, to take down all of these phishing emails and fake online sites. 113,000 fake online shops. But you can imagine 2020 when it's like, oh, the shops are shut, where do I buy something from? You don't want to end up entering your payment information into a fake online shop. Who does? So the fact is, there are at least 113,000 fewer of these things out there. It's got to be an inherently positive thing. When you think of the fact everyone's had to work from home, we've been more reliant on the digital world to at least be able to work in some semblance. I mean, you know, okay, the UK economy's jumped off a cliff this year. Can you imagine if we didn't have the internet to allow us to communicate, to allow us to buy and sell goods, to allow businesses to continue. It would be a darn sight worse than what we've had, and the NCSC has at least tried to make that environment, that digital world, a little bit safer. I mean, even down to stuff like the 0.5 there, the exercise in a box, free training available to corporations, to boards, to teams, to say, plan through your response in the event of a cyber attack. Take some time. I mean, if you're currently looking for things to do during furlough, as a team, spend a day going through exercise in a box. Set up a video call, work your way through these exercises collaboratively, learn about how to keep your organization's data safe so you don't end up like some of the other corporations, like Marriott and VA, being fined. But they're putting this information out there for free. You don't have to pay for it. No other government agency in the world is doing this for its economy, for its businesses, for its people, to try and stay safe online. And then just some of those other points, like defending the NHS. It is not long. It was only a few years ago we had the WannaCry attack that took down the NHS. Can you imagine if this year, when we're reliant on this to get us through these spikes of COVID-19, imagine if the NHS went offline for just one weekend, which is what happened in 2017, and a few trusts were affected by this. Imagine if that happened now, and touch wood, he says, the National Cyber Security Centre is keeping the NHS safe. It's defended democracy. We've had, the 2019 general election that finally settled issues around Brexit. At least it was able to have, you could vote, people could register to vote, they were able to carry out their votes, they were able to receive their postal voting forms, and the whole exercise was undertaken without fear of it being compromised. And we've seen where that can unfortunately not be the case in some other countries. So this is a fantastic book. And finally, that number 9 bit, encouraging women to think about a career in cybersecurity. All I can say is please, to anyone out there thinking, what should I be looking at for a career? If I have to feign interest in talking to any more white middle-aged men engaged in cybersecurity, there's some of these things. There is a lack of diversity of thought around cyber and how people are using technology and how the risks work. If I have to go to another conference and feign interest in talking about football, which I am not a fan of, I think I'm going to end up screaming. So we need to have far more diversity of thought within the technology industry dealing with these issues on a day-to-day basis. Because only then are we going to properly pick up all the threats, and only then you're going to be able to properly deal with them. And at the moment, it's a very narrow strata of society engaged on this. So let's get as many people from as many different backgrounds as possible to engage and join in an industry that is booming, but is crucial to keeping us all safe online.
Yeah, definitely. Yeah, I think the last point is very important due to like diversity and things like that. And yeah, the only negative thing that was probably discussed in this whole report, or the video, at least the video I watched, was regarding ransomware attacks, and how not only have they seen an increase in the ransomware attacks, but they're also seeing a change of the methodology of those who are carrying out these attacks. So ransomware attacks, like we're going to talk about in the next story, about a company in Finland, they're not only threatening to withhold data now, they're actually threatening to publish this data as well. So that's having a bigger effect on companies, and I think that's why we're seeing a big increase in ransomware attacks. Because Peter, like when we started doing this, I think we're on episode 19 now, so months and months ago, near enough at the start of lockdown when we started doing these, we didn't hear about cyber attacks happening as often. And now there seems to be a cyber attack that we're talking about in these episodes every single week. And I know when I started working at Digital Law a couple of years ago, it wasn't a regular occurrence that you'd hear about a cyber attack. Whether they're just getting more published now, or whether it's just becoming more of a regular thing. But I think 723 of the most serious cyber incidents, that's just showing that there's only 723 that are classed as serious.
Yeah.
There could be thousands and thousands and thousands occurring every week.
Absolutely right. And I mean, I think you're absolutely right. And the thing with, yes, the malware and the ransomware is it evolves all the time. But one thing I've learned recently is how easy it is to buy the technology to allow you to send these things, and to send very convincing, for example, phishing emails to people that could contain really awful links and ransomware. So the minute you click on it, you're locked out of your data and everything, and charge Bitcoin to get back in. It is very easy to do it. You don't have to be, you don't have to be able to code. You don't have to have labyrinthine knowledge of how technology works. All it takes is very often going on to having a Tor browser, going on the dark web, paying about $25 for a few programs, and then that's it. You can go out and do this stuff, and it's unfortunately very easy for very unskilled people to do this and then still profit from it. So that's the big threat. And yeah, 723, that's a lot. That's something most serious. There are tens of thousands out there that never get reported. No one knows anything about, but it's still a crime, still a statistic, and still victims on the end of that.
Yeah, absolutely. So that leads on to our next story, and I think this is our final one for today as well. So this is regarding hackers that actually blackmailed patients treated by a psychiatric clinic in Finland. So the cyber attacker actually used a novel cyber weapon, which briefly surfaced in one of the shadier parts of the internet, so on the dark web, this month. So the file actually contained years of psychotherapy notes on nearly 1% of the Finnish population, and this was stolen from one of the largest groups of private clients, Vastaamo. So for 3 hours, the personal data of MPs, the police, celebrities and children was actually exposed. So this file was actually uploaded onto the dark web for anyone to see who had access to that. So and more than 40,000 people were actually held at ransom. So the hackers actually grabbed the unencrypted file of notes from the company around 2 years ago, and the attack actually stayed secret for quite a while until last week, when victims actually started receiving emails threatening to publish their data unless they paid from around 200 euros to 500 euros in Bitcoin. And the company whose data this actually came from as well was demanded to pay 450,000 euros. So that is a lot of money, especially what is going on at the moment. But then the hacker started to leak hundreds of details every day onto the dark web until the entire file was accidentally uploaded, so someone on the dark web could help themselves. So the cyber attack hasn't thought to be that successful in terms of getting as much money as they thought they would from the Finnish population. They've only got about tens of thousands of pounds, which is quite a lot of money still, to say how many people's data was put out there as well. But I think the most important bit here is the bit right at the bottom, which is that Finland's National Intelligence Agency have said that the database could be a gift to the foreign spies. So yeah, it'd be interesting if anything comes from this and what information was actually on that.
Indeed, exactly right, Laura. You know, the funny thing with these ransomware attacks is that they affect a lot of people, but actually very often those behind them only then make a few $1,000, a few €1,000 out of it. So even those behind WannaCry and Petya and the North Korean ransomware attacks a few years ago, they reckon that they only made less than $1 million out of really big high-profile attacks that took down some massive corporations. Because of course those corporations don't turn around and then pay the ransom. They just go and then have to reset their systems and start again from scratch, and hopefully rely on the backup that's been taken. So very often, do they get much in the way of ransom? No. Do they cause a huge amount of anger, annoyance and upset to people? Yes. And in this instance, it's the fact that you've got incredibly sensitive data, if not the most sensitive in terms of people's private psychotherapy notes, you know, the most private, intimate things they've shared with a therapist. You know, let's face it, you're only going to go to the therapist and talk about it if you really have to. So it must be serious. It's not, you know, stuff about everyday trials and tribulations. It's serious stuff that people are going to be discussing here. And that sentence at the bottom is crucial: a gift to foreign spies. I mean, imagine if you could then hold something over police officers investigating something. Imagine you could hold something over politicians, heads of state, or people in authority, or to be able to then ransom a celebrity and squeeze them for some of their wealth. It really doesn't bear thinking of, and it will have been a gift to foreign spies. It will have been a gift to criminals generally to then be able to extort both money out of people or to then potentially influence them. You know, if you're talking about business leaders here, could you influence markets? Could you influence decisions? Can you influence those decisions that police and law enforcement even might end up carrying out? It really doesn't bear thinking of. And therefore, yes, it's the sheer volume here as well. 40,000 people having their notes leaked, and this is only the one that we've heard of. How often does this happen, where it's in countries where they may not have a statutory duty to report these sorts of things, and then try and cover it up and push it up? Really doesn't bear thinking about.
No, definitely, and I think it's worth mentioning back to the NCSC report that we've just spoke about, how there is a change in the way that the methodology is coming out in these attacks. So in a normal attack, like we've seen the WannaCry and things like that, they just withhold the data. They've not then said to them, right, if you don't pay this, we're going to leak this data. Now, so people have the option of not to pay, because if they've got a good backup system, you can get all that data back. Whereas now, because of everything's changing and the way that these criminal actors and cyber attackers and things like that are thinking, and the way they are trying to change the way they're performing their attacks, to then threatening to publish this data, which then would obviously result in a data breach.
Exactly. And it's as this evolves, as the volume becomes ever greater, these are the sorts of risks to look at. And again, I'm pleased that at least in the UK we have the shield of the National Cyber Security Centre, which hopefully would make it more difficult for something like this to happen.
Yeah, absolutely. So yeah, that's everything we've got time for today. So just a little reminder about the special offer we have on for our listeners. So this is our GDPR compliance manual for legal practices. So this was originally on sale in May of 2018 when GDPR came into force at £195, but is now down around 50% to £99. So this is available in digital copy and also hard copy as well, just an extra £5 for postage and packaging. So I'll just pass over to Peter to just give you a little bit more information about the manual itself.
Thank you, Laura. Yes, so this is our guide that actually contains practical guidance on what to do in order to demonstrate best practice when it comes to your data protection. So, you know, if you've read through GDPR, it's great at telling you you need to show that you're at this standard, show that you're at that standard, but it doesn't actually tell you how to do it. This guide does that for you. It contains forms and templates and checklists, ideas of best practice, hints and tips on how to take some of the existing things that you're doing, tweak them a bit so that you're then regularly producing evidence that you can use to hold in front of the data protection regulator, the ICO in the UK, and say, look, we are engaged in best practice. We've been doing everything we could to demonstrate compliance with GDPR. And this gives you the practical tools to do that, and a mere snip there at half the price. So please do feel free to contact us and buy your discounted copy.
Yeah, so you can either drop us an email to admin at Digital Law UK or admin at Anson Evaluate UK, AnsonEvaluate.com as well. Sorry. So thank you once again for everyone who listens to this podcast. So just a reminder, these are usually recorded on a Tuesday at 4 p.m, but they're also always available on demand afterwards on our website, and also as a podcast on your favourite podcaster channel. So yeah, thank you for listening, and we will hopefully see you next week for episode 20. Thank you, everyone.